Yes,
May I please, my lord? My lord, I beg to mention item number 32, my lord.
32. Yes.
My lord, I have taken the consent of the other party, my lord, appearing for the respondent. I humbly pray, my lord, the matter may be adjourned for today and fixed after 3 weeks, my lord.
3 weeks.
Yeah.
Mr. On the prayer, Mr. Opad and counsel for the respondent
My lord,
and on the and as consented, let it and as consented by the and counsel for the appellant, let this matter be listed after 3 weeks.
my lord.
Lordship, I beg to mention item number 28 on behalf of Mr. B. Sharma.
20?
H.
Ah.
The
Okay.
council is out of station, maybe listed after 2 weeks.
On the prayer of
B. Sharma.
Hmm?
B. Sharma.
B. Sharma, learned counsel for the petitioner. And Mr. So-and-so, learned counsel appearing on behalf of Mr. B. Sharma, learned counsel for the petitioner. Let this matter be listed after 2 weeks.
2 weeks.
Hmm.
Yes. Lordship, with consent of both parties, I would like to mention item number 6. Matter may be taken up after 3 weeks. Lordship.
On the prayer of Mr.
I'm for the petitioner, Lordship. On behalf of El Parme.
So-and-so, learned counsel appearing on behalf of Mr. El Perme, learned counsel for the petitioner, and the prayer not being objected to by learned counsel for respondent. Let this matter be listed after
3 weeks, Lordship.
2 weeks.
3.
3 weeks.
3.
3 weeks. Yes.
May I please yourself? In item number 11, I was supposed to file additional affidavit on behalf of the petitioner. I'm seeking some accommodation.
Further 2 weeks time is granted to Mr.
Bitaba yourself.
You are not Bitaba.
Bitaba.
Bitaba,
Yes.
learned counsel for the petitioners to file affidavit, additional affidavit.
Yes. Sir.
Yes.
Also, you said 12 and 14.
Hmm.
Kindly accommodation.
There also
Yeah,
additional
no,
affidavit.
not an additional affidavit yourself.
Then you said on the prayer of Mr. So-and-so, let this matter be listed after 3 weeks.
Okay, yourself.
Same order, 12, 14.
Yes, much obliged.
May I, Lordship? I beg to mention item number 15, Your Lordship.
15.
Yes, I'm
Yes.
appearing on behalf of respondent, Your Lordship.
Yes.
I need some more time to file our affidavit, Your Lordship.
Okay. On the prayer of MS,
Tirimi,
the remit learned counsel for the respondent. 3 weeks time is granted to file affidavit.
yes, Lordship.
Lordship, there is also an interim order. It may be continued.
MS so-and-so, no, the interim order passed earlier, shall continue.
Obliged.
May Lordship, Lordship, I would like to mention item number 31. Matter may be adjourned for today.
Yes.
As the leading counsel is out of station, Pitamin, I on behalf of Pitamin.
Mr. So-and-so, learned counsel for the learned counsel appearing on behalf of Mr. Titamin.
Pitamin.
Pitamin. Where it is? Pitamin, learned counsel for the respondent, who is stated to be indisposed today. Press for listing of the matter after 3 weeks. Praise the Lord. List after 3 weeks. Mr. So-and-so, Jitado, learned counsel, additional PPS.
I oblige. Your Lordship, item number 9. With the consent from the other side, Your Lordship, here we will be filing additional affidavit.
Additional affidavit or
Yes.
reply?
No, additional affidavit.
Mr.
M. Kambo.
M. Kambo,
Yes.
learned counsel appearing on behalf of Mr. Arsenal, learned counsel for petitioner, fresh for 2 weeks time to file an additional affidavit.
Yes.
Additional affidavit. Praise the Lord. List after 3 weeks. 2 weeks. Yes.
Oblige.
Item number 1.
Please, Madam.
Yes.
Madam, the accused person is between this law. Accused person is was arrested on 29/7/2025. Allegation that.
The regular bail.
Yes.
Heard MS M. Karbak learned concept for the applicant and MS El Hage learned additional PP for the state. This is an application under section 483 BNSS 2023 frame program to build the accused person. Namely, Sri Jiten Biswas in connection with Bandardua PS case number 56 of 2025 under section 21 bracket small b bracket close of NDPS Act. Call
Okay.
for the scanned copy of the case diary.
Yes, Lordship.
List after a week. List on?
Yes, Lordship.
Six.
List on 6/11/2025.
Ablator.
Item number 2,
Yes.
Lordship. Lordship, the joint criminal petition is filed under section 528 BNSS.
This is an
Invoking the-
application under section. What is the offense?
Offense is under 384,
520.
Lordship.
528 of the BNS. Praying for quashment of the criminal proceedings. Charge sheet has been filed.
Charge sheet has been filed. and-
Charge has also been framed.
Yes, Lordship.
Criminal proceedings in
Yes.
GR case number
882/2022.
88. Where do we get it?
Lordship,
Where
page,
do
page
we
number
find it?
6.
Huh?
Page number 6, para 7.
No, papers.
Lordship, it is mentioned in page number 15 also in the order copy of JMFC.
15.
Yes, Lordship.
(882) of 2022 under section 384.
Yes, Lordship.
IRC on the basis of settlement
Yes, Lordship.
between the petitioners. Mr. So-and-so, call for the scanned copy of the trial court record. Mr. So-and-so, learn additional people and appears for the state. List
Much of
after 4 weeks.
item number 3,
But
FIR, quashing of FIR.
FIR also in my lord, order by which charges was framed. Under 498A, my lord,
Then we'll say proceedings.
my lord,
We'll say proceedings.
Yes.
Quashment of proceedings.
Quashment of proceedings.
Yes, heard Mr. Deepang learned concept for the petitioner. By, this is an application under section same, huh? Praying for quashment of criminal proceedings in GR case number
914/2021.
914/2021 under section
498A.
498 only A within bracket capital A IPC. Call for the scanned copy of the trial court
Try for record.
MS so-and-so. And appears for the state, huh?
So notice may be served to
Ah.
respondent, but to
Petitioner land council per district steps for service of notice upon response number 2. Allegation is by your sister-in-law.
Yes, my lord.
What's wrong?
They have, but it's a very unfortunate issue, my case, my lord. Against my younger brother's wife's brother-in-law, elder sister's husband, there's a allegation of POXO against my younger brother's daughter. That is the mother of the complainant, my lord. The difficulty is she was raised by them, her elder sister and her brother-in-law. After 5 days, she files an FIR. There is no material, my lord. All other charges has been dropped. 498A, there is absolutely nothing, my lord. In fact, I was praying for an interim order, my lord.
Okay. Pending production of the trial court record, the scanned copy of the further proceedings of GR case number
Yeah.
so and so pending before the,
JMFCU.
you just write on top also pending before the so and so, huh? Judicial Magistrate First Class,
Yeah.
UPA, shall remain suspended.
Problem.
Same order
Same
in item
Alright.
4. Huh? Same order item 4.
Justice service affidavit file करें actually 16/6 करना है उसके बाद 18 justice service completed affidavit
Item number 5,
My lord, I'm sorry, my lord, since my name was not reflected, I did not bring the brief, but I just had my learned friend have it checked.
Which one?
Item number 5. My name is not shown in the court list, so I did not. I just came to know here.
What is
But
the matter?
I'm told if your office not indicate that justice service upon 13 and 14 has been taken and affidavit has also been filed.
Yeah, there's the order that the services are complete.
My lord, I'm sorry, but I could not check. I just came to know that matter has been listed. My learned friend had it.
respondent over here.
Otherwise, my lord, let me discuss some other day and my directed my name may be shown. I will check up the file.
No, 13 and 14 is complete. Anybody is appearing? For 13 and 14. You are for the
I'm
petitioner.
for the petitioner. man.
What is the matter?
This is regarding my lord, seniority, man.
Okay. 2019, 15.
No, it was hard, in fact. And the honorable court was of the view that 2 other respondents are required to be implemented. That is how they came to be implemented, and there was some difficulty serving notice upon them.
So you are challenging their promotion,
Not exactly promotion, my lord,
seniority,
retrospective, by which they were regularized retrospective.
regularization,
Already,
their regularization with retrospective effect,
yes,
saying that they are not eligible.
yes,
When the
yes.
date when they were shown to be
date, yes.
regularized.
Yes. And then nobody could be given retrospective promotion who were not even born in the cadre to the detriment of others.
Who is who is for the state?
Mr. Pada, I think, standing counsel.
Tourism Department.
Yes. I'm sorry, but I'm a bit handicapped because I don't have the brief.
The matter is very simple.
Actually,
In 2015.
yeah, it was hard actually.
Anyway, on the prayer of Mr. Deepang Learned Counsel for the petitioner who submits that matter may be listed. He could not. He has failed to notice that the matter is listed today. Therefore, press for a short accommodation. Lister. We have already recorded that the services are complete.
Yes.
None appears for the respondents, including the Standing Council Department of Tourism. Lister. Next paragraph. Considering that matter is pending since 2015, let this matter be listed after a week. After a week, on which date, please, it is made clear that on the next date, matter shall be taken up for final determination, even if the parties, even if the respondents, respondents are not, even if the respondents fail to appear.
My lord, may direct that my name be reflected, my lord.
Registry to reflect the name of Mr. Deepang Learned Counsel for the petition in the cause list.
Oh.
Yes.
item number 7,
Yes.
Lordship, I have filed my additional affidavit.
Saying what?
As directed by this court.
This code on 20/12/2024. My lord,
It can.
what is matter before the lordship is pertaining to the transfer of the land. What my case is, my lord, so far my prayer is, my lord, a limited prayer as to why the direction shall not be made to the deputy commissioner to complete the transfer process, as I have submitted a give deed before the concerned authority.
Okay.
So this honorable court has order on the 2012/24 to ascertain that in order to transfer the property, whether that should be in the form of gift deed or in the form of sale deed.
Hmm.
So I think that has been filed by the government.
Yes, what it is?
Lordship. As for this lordship in the
Affidavit, additional
Yes.
affidavit.
additional affidavit, page 21 itself, lordship. We have referred to the Land Settlement and Records Act 2000.
Page,
Lordship,
page
case starting from 2021,
21.
last para 2,
Para 2.
page 20. Here, we have said that can be transferred. Rights can be transferred. They have said that to the submission subject to the declaration and satisfaction of the district authority.
As for act and rules,
As for, yes.
in the event of a land transfer on sale and purchase, the government shall have the right to recover stuff.
The right to transfer the allotted land to any member of the indigenous Arunachal Pradesh scheduled tribe of the state from payment of this aid may be prescribed by the government. Under section 89, every person who has become a landowner under subsection 1 of section 88, the transferable rights.
Where it is section 88? Shall have transferable rights in the land to the successor, subject to declaration satisfied by the district authority. Then Settlement Act. Section 89 or 88. Accrual of ownership on government land allotted for agriculture purposes and agriculture purposes. Rights of landowners. Every person who at the commencement of act holds any land from the government for agricultural purposes. Is it for agricultural purposes? No?
No.
And the successor in interest shall, subject to provision subsection 2, become the owner thereof agent from such commencement, provided that all lessees of government land on the date of commencement act shall continue to hold such land on lease as per original terms until such time as per the government order for other than agriculture are framed under appropriate provision law with the right to transfer the allotted land to any member of the indigenous. Okay, it's in proviso. Rules for allotment government for purpose other than shall continue. Provide all eligible government land on the date of government shall continue to hold such land to lease as per original terms until such time as per appropriate rules for allotment of government land for purpose other than are framed under appropriate provision that will be right to transfer land to any member in national tribe of its state on payment of fees as mentioned. No rights will accrue under subsection 1 in respect of land which area or the requirement of public requirement. What is rule 133? Under subsection 1 of section 12, an APST individual who is interested for a land and may apply for such land in a prescribed form in the district on payment. This is for allotment.
Yes. One, subsection one.
The land shall not be transferred by allotee within 5 years from the date of allotment without the prior consent writing of the company. However, in the case of immediate family relatives like father, mother, wife, brother, children, land can be transferred without the stamp duty, except the conditions mentioned below in payment, subject to payment of land revenue. Yes. So according to you, unless the consent is obtained from the competent authority, it cannot be transferred.
Since, but then of the record of it, then the
No, that is when you were allotted.
My lord, I was allotted in the
You are a transferor or are you a transferee?
my lord,
Petitioner is a transferor or transferee?
transfer. I'm Donny.
Transferee.
Yes,
You have purchased the land.
yes,
Huh?
yes. Well, land with building. In fact, my lord, so far
So it was initially allotted which year?
it was initially appointed to the other person that I have not concern about it, my lord. So
See, rules concerned. You may not be concerned when it was allotted. Because it says it cannot be transferred within 5 years from the date of allotment without the prior consent in writing of the competent authority.
exactly, my lord, that is the
So is it not relevant?
my lord.
The initial appointment is not, allotment is not relevant or what?
My lord, this is relevant, but
Then,
to that expect, my lord, yes, I should have, my lord, ready with it. But so far, my lord, my case is concerned since the matter has already been transferred to me. It was on the 8/7/2021. Then that transfer was made in the form of the gift deed, my lord. So, so far, my lord, that
it doesn't talk about the mode of transfer, whether it's gift deed or whatever, it's permissible.
exactly, my lord,
Privacy, it appears that it's permissible
that was the
with certain condition.
not sell it, but not
Hmm?
sell it, but
No, that's what I'm saying. Mode of, without mentioning any mode of transfer, it grants right to transfer. There's no specific mentioning the mention of mode of transfer,
no.
whether gift deed or sale deed, whatever.
My lord, they have
But
simply.
in case it is transferable.
My lord, simply mention that the document on which the registration is instrument of the gift immovable property, my lord.
Where it is.
Under Registration Act, my lord, in page number 22. 22 of the additional affidavit, my lord. Yes.
also in the petition is Donald's allotment is also annexed in the petition.
So what is to be done? You are for?
Your Honor, I am for private respondent number 4 and 5.
You are objecting it.
Yes, my lord.
Yes. Have you received the additional affidavit?
Not yet, my lord.
Or we thought we'll dispose of the matter.
Yes, my lord, here in the,
Madam, you can consider his case and decide in accordance with the act and rules, provisions of the act and rules. If it's permissible, you can do that. Allow it. If it's not permissible, as per the rules. What he's praying is that initially it was kept pending because there is a injunction or interim order by the trial court. Now that has been disposed of. Still then it has been kept pending. Yes, what is your stand?
yes, my lord, here in this case, my lord,
Yes.
the additional magistrate come here, my lord, capital magistrate has state the proceeding of the transfer of the property was on the ground that my lord, CO Maro has sent order, my lord, on basis of the cover decision that my
It has
lord,
been disposed of.
but
Isn't
my
it?
lord, no, my lord, they did not challenge the cover CO order, my lord, passed by the CO, my lord.
No, thereafter that has been settled.
Yes.
No, my lord.
You are far behind. Is not it, Mr. Modi?
Yes. Yes, my lord.
After the interim or injunction order of the circle officer,
Yes,
right?
Yes.
There was a settlement
There was a settlement.
or the case was disposed of.
Disposed.
Where is the settlement?
Probably this, not be in this file, but that was there.
How do you know if it is kept in your self?
yes, my lord, we have
without
also not
placing-
received such from our client, my lord.
Huh?
In this regard, we have also no
See,
instruction from
the
our-
additional affidavit pertains to the provisions of law. Yes, you furnish. Difficult. Otherwise, we thought of disposing of the matter. Or will direct the deputy commissioner to consider and dispose of it as per the provisions of the act and rules. What do you say?
my lord, we have not received instruction from our client that they have settled the matter. Otherwise, my lord,
That is your state,
yes, ma'am.
right?
Yes.
Or that matter has been disposed of.
Whether it's in this.
Such instruction, my lord, we have not received yet.
Have you filed the affidavit
Yes, my lord, we have filed
saying what?
that, my lord, this matter is not maintainable on the ground that, my lord, the order passed, my lord, order passed by the CO should be set aside or caused, my lord. Thereafter, my lord, this transfer process can be challenged, my lord. State of- Yes, my lord, the transfer process of the,
He
What?
said that after that there is a settlement.
yes, that thing, my
And
lord.
that case pending before the circle officer or
Ma-
Kebang,
Circle officer Maro.
that has been disposed of.
That
That
thing,
is his stance.
that thing, my lord, we have not received that such thing from our client.
Is it your case?
Yes.
Is it?
Yes.
Where you have stated?
Therefore, thereafter, we have placed the
Where you have stated that?
ballot in para number 11.
Yes, read it.
The circle officer Maro has decided the land dispute in favor of the private respondent. However, the private respondent has failed to establish the compensation amount as has drawn from the land in dispute. In fact, the petitioner have their own separate land from where he got the compensation amount to purchase the Yes Bank building at Itanagar in the name of the petitioner number 1. Further, it is pertinent to mention here that the private respondent number 4 and 5 has already received their own 80% solatium compensation against their respective lands acquired for the establishment infantry brigade less 1 infantry army headquarters by the defense government of India at Bararupo Circle Maro Upper Subansiri district. So my contention is that whatsoever they have claim made, but they fail to establish that from where the compensation was get, they have got the private respondent have got their compensation
Sir,
From
I
there-
am not on that. I'm
Fine.
asking whether after the decision of the circle
Yes, my. So
officer
my contention
or
is
the
after
KEBA,
the-
whatever,
what.
what was the settlement? They're saying there is a order of the circle officer.
Yes,
Are you saying so?
yes, my lord.
Where it is?
My lord, it is in their, your number, page number 34 of the
Writ petition.
Yes, Your Honor. This is the order of the CEO, my lord. On the basis of this, my lord, the capital.
34.
Yes.
Page 34. Yes. Whereas compensation be located on person is being transferred to the mission. Therefore, it is that amount the company are receiving is like that. Yes, that is village authority has decided the title. Huh?
Yes. My lord, Village Authority has directed the petitioner number 1 and 2 to pay at least 20 lakhs out of the compensation amount, my lord.
Where it is?
It is in, my lord, my affidavit, my lord. First, Keba decision is page number,
Findings of the hearing.
annexure
Here-
number 2, my lord.
No, page 42 is what? On the hearing of the claim system, by complaint and respond willingness, witness in all respect, the village council in the residency of Maro has come to the following. All the speakers agree to the claim of Sri Takar. Takaru is you
Yes, my lord.
over the land plots, zoom lands of so and so and so. Does the title ownership of the ancient land of the with two witnesses still alive, so it's and so. This order dated 23/01/2023, page 43, finally. Operative, what about this?
This is my lord, start from 35 to page 43.
This is by
This is passed by the
circle officer.
circle officer Maro.
Mhm.
The conclusion is in the page number 43.
Yes, what do you
The
say?
claim, the claim of the ownership of Sri Rui, Taka Rui, over the lands of the plot of the June Peel at the Repa Reme upper portion and the Helen stand to be the true and claim being to the rightfuls of the Minya Rui, son of Rimi Rui, has been rightful ownership over the land and the plot of the June cultivation, June Peel at Repa Reme upper portion and Helen. So this is whatever mentioned is pertaining,
Your respondent number?
4 and 5, my lord.
4.
Yes,
You
4 and
filed-
5.
Where is your, the documents you would like to refer?
Yes, my lord, in my affidavit, annexure number 2, page number 15, and 16 is the type of copy. This is the past Keba, my lord, wherein, my lord, petitioner, they did not appear, my lord.
Then
Here, and here, my lord,
page 22, annexure 3 is,
yes, annexure 3, here, my lord, petitioner also appear, my lord.
so,
Here also, my lord, Keba directed the petitioner to pay at least 20 lakhs out of compensation amount, my lord.
that is something different. He has purchased the land.
Yes, this land was, my allegation is that, my lord, this property was bought by the petitioner out of the compensation amount. Therefore, my lord,
Why is the order of circle officer not to
eh,
process for transfer? It's a conditional order
Yes.
subject to decision by the village authority. That has been decided. If you are not, if he is not paying, you file an execution petition for recovery of this 20 lakhs. Whether this is purchased from him or not doesn't make a difference.
On the basis of this CO order, matlab, this deputy commissioner has.
Yes, he
stated-
cannot do it. That was a conditional order. Thereafter, the KEBA has decided the issue.
Yes,
So they deciding in your favor that you be paid with 20 lakhs.
yes,
Now your objection is that until it is paid
yes, my lord,
to you,
yes.
land cannot be transferred. That cannot be.
Because, my lord, this property is bought out of the compensation. amount
Doesn't
before,
matter. It's a different subject.
Yeah.
You file an appropriate application or initiate appropriate avail or a remedy for recovery of 20 lakhs from him. That will be a different issue.
Yes.
Not from him. You are the transferee or transferor?
Transparent.
Transferee.
So there
Who is the transferor? He's a petitioner.
No,
no
my lord.
one
Ali will leak one development.
Sri Lika Hali.
Who is Lika Ali?
He was the person whom the government has allotted the land
Ha.
in the years 2012.
Hmm.
So in the meantime, in the years 2018 or 2021, that was transferred in my name.
Hmm.
So the objection from the private respondent is only that you have bought this property with the compensation.
Initially,
amount.
what is Hali?
Lika Hali.
Lika Ali.
He's
It was
putting
transferred to?
me.
Ha. Then you have,
And accordingly, I have submitted the document before the concerned authority, that is the deputy commissioner, to,
okay, you have purchased.
yes, I have purchased, intense the owner. So after reaching up to this extent, in the last occasion, so far, I remember.
Where is the order of, is there any order of the deputy commissioner?
So far, no.
Rejecting your, or keeping it abeyance or keeping it pending in view of the matter or dispute between you and the respondents? Is there any order? Or just simply, or simply kept it
Gave it pending.
pending?
And for that, I have submitted the representation on 23 March 21 also.
So, we'll dispose of it.
It's my. Yes, my.
What do you say?
Yes, my lord. My only submission is
Hmm.
that, my lord.
What?
Yes, my lord. They should have first challenged the order of CO.
No.
Or then
This was a conditional order. Ultimately, your dispute with him has been decided.
yes,
It's a different cause of action, different matter. Now, you
Yes.
may avail appropriate remedy.
however, my lord.
Execution of KEBA decision
Yes, my.
for recovery.
However, my lord, this property is bought out of the compensation amount. That's why it's the appointment.
Doesn't matter. You can initiate recovery. Yes, or Mr. C. Modi, Land Council for the petitioner. Petitioners,
Yes, my lord.
why two? Why? Why two petitioners?
My
You have
lord,
jointly bought or what? You have jointly purchased.
my lord.
Your brothers or what?
The petitioner number,
1 and 2.
One and two.
2 and 3. Who are there?
For my lord, the family members
You have jointly purchased.
jointly purchase.
Okay. And also heard MSG at Learned, additional senior government advocate for respondent number 1, 2, and 3.
Yes, sir.
And Mr.
Arriba, my.
Arriba, Learned Council for respondent number 4 and 5.
Yes.
Next para. By filing this writ petition, the petitioners have sought for a direction to the Deputy Commissioner Capital Complex, Itanagar and DLRSO Capital Complex to complete the process of transfer of the land and building. What is that? Yes Bank
Yes,
land and building. It is situated where? Measuring.
88 square meter.
Where you have said? Where you have stated?
In the annexure 1 in my GW in page number 15. E sector located at the E sector Itanagar.
What is this?
88 square.
88 square meter, land measuring 88 square meter with building,
Yes.
located at East Sector, Itanagar. Please stop. Next para. It is the case of the petitioners that the land measuring 88 square meter and the building standing on the said land at E sector, Itanagar, has been gifted by one Sri Lika Hali. By way of gift deed. We have not purchased it.
My lord officially give this to be read.
Gift deed. List of list of the land was initially allotted to the said Lika Hali in the year 2012.
12.
List of the gift deed transferring the land and building it's only land or building.
Yes, land with building.
Where it is? It doesn't talk about the building.
88 square meter where in the building is also there. Yes.
Where it is in the gift deed?
My lord, I'm looking it up.
Is there any other gift deed?
My lord, everything explained. There is land and there is a building over the land.
But gift doesn't talk about the building.
It seems so, my lord, particularly that's my lord, I trying to find out whether the building has been mentioned or.
It's not mentioned. It's a two-page gift deed. I have seen it. If you can show it, that's why I'm asking.
Not mentioned.
Please stop. The petitioners claim that although gift deed does not mention the building, comma, they have purchased the land including the building from the vendor, from the seller, from the said Lika Ali. Please stop. Next para. On such sell and purchase, sell and the gift deed, the petitioners have applied for transfer of the ownership of the said land before the Deputy Commissioner,
My lord,
Capital Complex,
capital.
Itanagar. Mr. However, the same has been kept pending since you have your application is of which date?
On 23rd March 2021, on page number 31.
This is what? This
Yeah.
page 2018 is not the application.
Yes, page number 18. It start from page number.
On 08/07/2019.
My lord.
Applied for so and so on so and so, the before the so and so on so and so, however so and so, so and so. It is a simple case of the petitioners that since the law permits the transfer of the government land allotted on lease to a transferee, non-consideration for transfer of the land gifted to the petitioners by the deputy commissioners is illegal, which deprives the right to property, right to have property of the right to proper to the petitioners. Mr. Next para. MS G at the Learned Council for the Learned Additional Senior Government Advocate submits that initially it appears that due to the order dated, where it is that order? 21/11/2019 passed by the circle officer. Whereby it was directed that no property shall be diverted, converted, and no immovable property shall be diverted and converted, both of the out of the compensation amount, particularly Yes Bank building, until the time the dispute regarding the title and ownership and the compensation and the title and ownership of the compensated land between the petitioners and the respondents are the private respondents are decided by the village authority or the court of law. Mr. She submits that in the subsequently, since the dispute between the petitioners and the respondents, private respondents with regard to right and ownership of the compensated land has been decided by the village authority as accepted by the circle officer Maro on 23/01/2020, there may not be any impediments for the deputy commissioner to consider the case of the petitioner. With regard to transfer of the land and property in the name of the petitioners, in as much as the law permits that the land allotted may be transferred to a transferee with certain conditions attached there to. Therefore, please stop. That's Mr. Learned Counsel appearing on behalf of Learned Counsel for the respondent number 5 and 6, 4 and 5 submits that despite resolution of the dispute by the village authority in clear terms to the effect that the petitioner, the respondent number 4 and 5 are the owner of the land compensated, for which the compensation has been received by the petitioners, and out of the said compensation amount, the land in question, including with the building, has been purchased by the petitioner. The petitioners are obligated, are directed, are incumbent upon to pay 20 lakhs to the respondent number 2, 4 and 5 in terms of the decision of the village authority as approved by the circle officer of Maro. Christoph, since the petitioner has failed to pay 20 lakhs to the respondent number 4 and 5 in terms of the village decision of the village authority, and the land and building has been purchased out of the compensation amount accrued to the petitioner, a compensation amount of a land of the petitioner, the petitioner, the land cannot be, land and building cannot be transferred in the name of the petitioner. Please stop. Therefore, it submits that you want money only. It submits that the petitioners may be directed to pay the 20 lakhs amount to the respondent number 4 and 5, which has been received by the petitioners for the compensation of the land of the respondent number 4 and 5. Next paragraph. I have considered the submissions of land council for the parties and also where is the materials available on that court. The petitioners appears to have purchased the land measuring 88 so and so square meter along with the building from one Sri Lika Hali located at so and so this sector. Remember? Itanag, Mr. On such sale and purchase. On such purchase, the said Lika, the actual allotee of the government land has made a gift deed on 8/07/2019 in favor of the in respect of the said land in favor of the petitioner number 1. You are petitioner number 1 only. Petitioner number 1. Mr. The on such gift, the petitioner on the basis of the gift deed, the petitioner number 1 appears to have applied for transfer before the Deputy Commissioner, Capital Complex Itanagar, which admitted the pending for consideration. Next para. The initially, in view of the order of the Circle Officer Maro, not to divert or convert the immovable property bought a purchase out of the compensation amount, including the land and building in question, until the time the same is decided by the village authority or the court of law or the court, the matter is kept pending. Subsequently, the dispute with regard to the entitlement of compensation and title and ownership of the land for which a compensation was awarded and received by the petitioners have been finally settled by the circle officer on 23/01/2020, whereby it is the claim of the respondent number 4 and 5 over the disputes between the petitioner and the private respondent number 4 have been held to be allowed In other words, it has been declared that the land for which a compensation was awarded belongs to the respondents, prime respondent number 4 and 5. It is also noticed that the village authorities, who has directed you to pay? Village authority.
Yes, ma'am. Earlier it was 30 lakhs, then second Gaba
It's
decision
okay.
it was.
Finally, it is also noticed that finally the village authority, by the order dated, by decision dated, so and so,
14 October 2019.
19,
Yes, my lord.
2019, has also directed the petitioners to pay rupees 20 lakhs. You are happy with the 20 lakhs
Yes, my lord.
to the
It led to the
private
bill
respondent number 4 and 5, considering that the land for which a compensation and award was awarded and the amount received by the petitioner.
Sorry, my lord. Gaba dated 28/10.
2810,
Yes, my lord. 2019.
2008, yeah. Page,
Page number, my lord. Type out copy is 20, my lord. Original copy is from
of
page number.
affidavit in opposition, huh?
Yes, my lord. Page number
Page
7.
20, affidavit in opposition of R4 and 5, huh? By the petitioners. Next paragraph. Considering on consideration, comma, it appears that the dispute between the petitioner and the respondents with regard to entitlement and the ownership of the compensation, land and the compensation amount has been finally settled by the village authorities and the circle officer Maro, and directed the petitioners to pay an amount of rupees 20 lakhs to the respondent number 4 and 5. List of which in my considered view is a different subject matter for which the petitioner, the respondent 4 and 5 will have a remedy under the law. List of the issue, the simple issue raised herein is for a direction to consider the process of transfer in accordance with law, or accordance with law, transfer process, the transfer of the land and the building which has been purchased and purchased by the petitioner from one Ika Ali, which has been, which is pending since 2019. This stuff. Although the respondent number 4 and 5 claims that the said land and building have been purchased out of the compensation amount, and until the amount is paid as directed by the village, as decided by village authority, is paid to the petitioner, same cannot be transferred, to which I am of the view that such a submission cannot be accepted in view of the fact that the remedy available for execution of the decision of the village authority or the court the remedy so and so for execution so and so of the said village decision of village authority, the court else lies somewhere else, which the respondent number 4 and 5 may avail. List of next paragraph. The and on perusal of the provisions of law under provision of law under Arunachal Pradesh Land Settlement Rules, Land Settlement Records Act 2000. Arunachal Pradesh within bracket Land Settlement and Records Act, bracket close Act 2000, and the rules from there under. Allotment of a government land on lease may be transferred to a transferee on fulfilling certain conditions. List of. Does the Deputy Commissioner is obligated under the law to consider the application for transfer filed by the transferee, transferor or the transferee in accordance with the law. List of. Next, having considered the submissions and materials as noted here in above, comma. And in the facts and circumstances, comma, I'm of the considered view that the Deputy Commissioner, Captain Complex Itanagar, is duty bound to consider the case of consider the application of the petitioner to for transfer of the said land and building, obviously in accordance with law. List of. Accordingly, list of. In view of the above, the petition is disposed of with the direction to the Deputy Commissioner Itanagar Kapli Complex to consider the application of the petitioners, petition number 1 for transfer of the said land and property, namely the land measuring 88 square meter with building located at East Sector Itanagar. List of. The within a period of 2 months, in accordance with law, within a period of 3 months from today. List of. It is provided that it is provided that the respondent number 4 and 5 may avail the appropriate remedy for execution of the KEBA decision dated so and so for recovery of this and the circle officer Maro for recovery of rupees 20 lakhs from the petitioners. List of. It is expected that since the land for which a compensation has been awarded and received, and the amount received by the petitioners, received by the petitioner is decided, is held to be belongs to the respondent number 4 and 5. The petitioner shall abide by the decision of the village authority and the circle officer. Right? You pay. Get transferred, but you pay. We're directing you.
No, Alan, the direction cannot be.
I can. I'm exercising jurisdiction. I'm also granting a relief equally. Balance. You have not, the file and you have not challenged the village authority, decision village authority and the circle officer. Have you challenged?
It's there.
So that is finality, nothing there, you pay.
Let them
You
file
have
the
district-
execution, matter.
No, I'm directing you. He may, I probably he may able, because it's very difficult. You must be,
To the extent.
you are conscious that it's very difficult to execute the village decision. All right?
Right.
So we're directing you to pay.
My lord, I am denying to this particular
No.
direction person. Because they,
You have not challenged the village decision of the village authority. Have you challenged that?
my lord, that I admitted that I have not checked.
Not challenged. I'm putting that. It has attained finality, therefore you have to pay. I thought I was saying expected. I said now I'll direct. Balance. Get transfer, pay it.
Let him file, my lord, execution.
No, there it's not. I'm directing. You pay. You may say that it's not a case. It's not your case. It's his case. You have made him a party. So we have to balance.
They are the party who are blocking me, my lord, in transferring his property. Anyway,
Okay.
oh, bless.
Red petition is sent disposal.
Deeply available.
Item number 8,
Bangala room. Yes. What is this?
I am for the private respondent.
Criminal petition.
Yes, they're challenging from the pleadings, I can't make out exactly.
That is why I'm asking.
Charge has been framed or not.
That is why I'm asking.
I read it last night.
Precisely.
I just,
Anyway, not interested. Did they stay or what?
don't think so, my lord.
Okay. Non appears for the petition on call. How about Mr. Deepak, London Council for Respondent is present. List. In the interest of justice, let the matter be listed after 4 weeks.
The state should have been made a party.
Anyway, you take up that all. But state is not a party.
Because state is prosecuting.
Okay.
item number 10,
Taba Penka. Yes.
Lordship, I am for the private respondent number 5.
Yes. You have filed your affidavit.
Yes, Dr. We have filed our affidavits.
Who is for the petitioner? It's after 4 weeks.
That's
Earlier occasion also, they were repeatedly submitting the court to file additional affidavit. This time they didn't. 4 to 5 occasions.
Huh?
4 to 5 occasions, they have been praying for additional affidavit.
Okay.
not something given lots because status quo is there.
Not appears for the petitioner on call. And no rejoinder affidavit has been filed by the petitioner as source for. List of MS so learned counsel for the learned additional senior governor for the state and Mr. B. Tapa. Learned counsel for respondent number 5 are present. Considering the nature of the issue involved and the operation of interim order, the interim, no, and the interim order is still, is in operation. And the, in operation against the respondent number 5. Status quo is against you.
Actually, they have.
Anyway, considering the nature of the issue involved and considering that the responses have been filed by the respondents, let this matter be listed after 2 weeks.
Item number 13.
Here, my lord, we need some more time, my lord, to file affidavit, my lord. I'm appearing for 1, 2, and 3, my lord.
What is your case?
Your Lordship, there are two issues here. So one is illegal occupation of my ancestral land, and one is
Only 2 issues.
no, Your Lordship, main issue land dispute, Your Lordship.
No, you said there are 2 issues.
Your Lordship,
I'm asking only 2 issues.
yes.
No, if there are 2 issues, we cannot add one more, any other issues.
No, Your
I'm just
Lordship,
asking, you said 2 issues,
no, sir, your main two issues, Your Lordship.
main 2 issues.
Yes.
Whether is the not main issues. There are some ancillary issues also.
Yes, Your Lordship, one
Tell us what is the 2 main issues.
Your Lordship, one is land acquisition process for this frontier highway, Your Lordship.
Yes.
And the one is for illegal occupation of this my land
Ah,
by this BRTF group, Your Lordship.
ah.
Because of this disputed land, Your Lordship, there is a delay in occupation for this frontier highway, Your Lordship,
Ah.
Lower Dibang Valley.
What is the dispute?
Your Lordship,
You show us how you claim on what basis you are claiming that lands belongs to you. So what do you want?
so first is, Your Lordship, for the BRTF to give us back our land, which they borrowed from us in the year 1977-78 for temporary use, Your Lordship, to set up grip for their temporary settlement and this helipad and all, Your Lordship. But even after the completion of their road and all, they are yet to leave, and they are now trying to occupy our private land.
You want that either it should be acquired or returned back.
No, Your Lordship, first, if they want to acquire, they need to follow the acquisition process, Your Lordship. We are not against acquisition, Your Lordship.
So either you want the land back or to pay compensation.
So, Your Lordship, exactly, sir. Compensation, Your Lordship.
So these are the 2 issues,
Yes, Your Lordship.
not the issues which you have mentioned.
So, Your Lordship,
To return back,
or
if not, if it is required, you pay
Yes.
compensation
a
by following
proper
the
acquisition process.
process
Land
of law.
acquisition.
These are the 2 issues.
Yes, Your Lordship.
One issue, in fact. Anyway, how many years or months?
For
They are still in occupation.
Yes,
yeah.
Your Lordship. BRTF.
And Mr. M. Tasalan, counsel for the petitioner. On the prayer of Mr. M.S. T. Wang, London State Council, and
Lordship,
so and so, appearing on behalf of Mr. M. Kato, Leonard Diaz. Further 3 weeks' time is granted to file their responses. Yes, list after 3 weeks. All right,
Let's, Your Lordship.
or you want early death?
Your Lordship.
Item number 16.
My lord, on last occasion, respondent number one short time spell reply.
What is to be done? Heard Mr. O Modi, learned counsel for the petitioner. Non appears for the respondent number one. And as per, and no affidavit in opposition has been filed as sought for. Mr. Respondent number one.
Lordship,
So,
I'm for a respondent. Lordship, today we are filing our affidavit in opposition.
no. Then in that case, Mr. So-and-so, you just delete the last line. Last sentence. The Mr. So-and-so learned counsel for the respondent number one submits that he would be filing his affidavit in opposition during the course of the therefore prays for listing of the matter
My lord, where's
after
it,
4 weeks
interim order?
as agreed to by the learned counsel for the let this matter be listed after 2 weeks,
4 weeks.
3 weeks. Interim order passed earlier shall continue.
Matter number 17,
Yeah, please, my lord.
This is
This is regarding my lord, quashing of, this criminal petition is jointly filed by the accused and petitioners. uh, For quashing of FIR dated 14/10/24.
what is the offense?
Offense is, my lord, it's section 74. 74 is, my lord, assault or use of criminal force to the woman with intention to outrage her modesty. And
Hmm.
another one, 115 bracket 2 is voluntary causing hurt. And 126(1) is wrongful restraint. And 3 bracket 5 is for common intention, my lord.
Hmm.
Out of this section, my lord, only 74 is the non-compoundable section, my lord.
Non-compatible and very serious.
So, my lord, here, my lord, the
How you are related?
my lord,
Who is the accused?
accused is she is petition number 5. Her name is Gyama Rasna, my lord.
Rest are informant.
Yes,
1, 2, 3, 4, and 5 are 1, 2, 3, and 4 are
they are the accused.
victim.
Accused, your honor. Accused in this case. Victim is petitioner number 5, Gyama Rasna.
Victim.
Yes, victim, and she is the complainant.
Rest are accused,
Yes,
including petition number 1.
yes.
Yes.
So, my lord,
How you are related?
my lord, the fact of the case is that, my lord, there is, due to some misunderstanding, there was a scuffle between the accused and the complainant, my lord. Actually, my lord, what happened?
What is the stage of the case?
Case is, my lord, it's charge sheeted, and now it's endorsed to the judicial magistrate first class UPA for trial, but it's not yet take cognizance, my lord.
Charge has been framed.
Yes.
Charge has been framed.
No, not yet framed. Cognizance has not yet take, your honor, my lord. Already charge sheet has been filed, and it has been endorsed to the, it's forwarded to the learned CGM, and as per order dated 8/5/25, learned CGM has endorsed to the learned JMFC for trial, my lord. So now, my lord, matter has been amicably settled, my lord, outside the court, the parties. So therefore, my humble submission before this, my lord. So this is the pit case, my lord can intervene, and
That's
matter.
why I'm asking how you are related. The accused and the other the victim.
Okay.
How you are related?
Okay, my lord. Actually,
What is your relationship?
relation is it's like my lord, my husband the complainant, she was with my husband. I have found my husband in railway station on late night along with the complainant. So, being a wife, I asked her, why you are with my husband late in the night?
So it's all resolved.
Yes. So before that,
Now it's all resolved.
yes.
Yes. What is let us see your settlement.
My lord, may kindly, page, yes, page 58, my lord. This is a settlement agreement, my lord.
Close 5.
Yes.
Both the parties agree and understand that in the event of any violation of the terms of this agreement, the violating parties shall be liable to pay a heavy fine as penalty to aggrieved party.
This is just to, it's a,
You refuse
Other-
to,
otherwise, Your Honor, my lord.
you
it-
still refuse to
No, my lord, it's just,
maintain the age-old tradition.
no, it's just like, it's kind of.
Yes, madam,
And
husband and wife.
yes, Lordship, this is already been settled, Lordship, and this injury is also simple, Lordship.
Okay.
I have no.
Yes, heard, mister. No objection.
No, Lordship.
Yes, Jita di.
Learned counsel for the petitioners, and also heard MS El Hage, learned additional PP for the state. Next para. By filing this application under section 528 of BNSS 2023, the petitioners, by jointly filing this application, have prayed for quashment of criminal proceedings pending before the Judicial Magistrate
First class, UP.
UPA, arising out of an FIR dated 14/10/2024 in connection with Pappu Hill PS case number 73/2024 under section 74 within bracket /115 bracket 2 126(1)(3) within bracket 5 BNS 2023 on the basis of the settlement entered between the petitioners. What is this? Is there any JR case?
Yes, my lord. GR case number 1058/24.
Where do you get it?
My lord, it is in my additional affidavit I have submitted along with the disorder, my lord.
Saying what?
It's regarding, my lord, endorsement of the case to the learned judicial magistrate first class.
Corresponding to, you just write, na? GR case number
Yes, 1058.
105 of 2024, huh? Next para. The case set up by the prosecution is to the effect that on 14/10/2024, a written FIR was received from MS Gamer
Asna.
Asna of Polo Colony, Naharlagun, that on 13/10/2024, at around 20:30 hours, while she was walking with her old friend Sri Subhas Nidak at railway station, Naharlagun, suddenly Mrs. Yanga Mara and her group consist of male and female, and consist of 10 male and female, attacked on her with iron rod on her head and using chili powder in her eye. List of next para. On receipt of the aforesaid FIR, Papunola PS case number 73 of 2024 under section so and so, 74. This 118 also.
No, initially it was 118, but after
No, then 74/118, bracket close 1, bracket, bracket 1, bracket close 126, bracket 1, bracket close 3 within bracket 5, bracket close BNS 2023. List of, on completion of the investigation, the police having found prior case established from the submitted the charge sheet on 07/04/2025,
no, on 24/04/2025.
24/04/2025
Yes, my lord.
against the petitioners number 1 to 4
Yes, my lord.
under section 74/115 bracket 2 bracket close /126 bracket 1 bracket close /3 within bracket 5 bracket close BNS 2023.
Oh.
You are not related. Family wise, you are not related.
Yes, my lord. My lord, sorry, my lord, it was forwarded on, charge sheet was forwarded on, 07/04/25, my lord.
/07
My lord, 07/04/25. Sorry, 25.
which is pending, and you just which is pending for consideration of the charges
No, it's not yet take cognizance, my lord.
for taking cognizance before
Yes.
the learned judicial magistrate
First
first
class.
class UPR. List of Mr. So-and-so learned counsel for the petitioner. Petitioner submits that the FIR, the case has been initiated due to misunderstandings. The submits that due to misunderstanding due to misunderstanding between the parties, between the petitioners, there was a scuffle leading to lodging of the FIR against the petitioners number 1, 2, 3, and 4 by the petitioner number 5. There was during this scuffle, there was attack and counter attack between the petitioners number 1, 2, 3, and 4 and petitioner number 5. which resulted in simple injury. List of the matter in fact pertains to claim and counterclaims with regard to what extramarital
Yes, my lord.
appears. Mr. However, being the neighbors having realized that the parties by the settlement agreement dated 30/08/2025 have voluntarily entered into a settlement and settled the matter. To maintain peace and harmony among themselves. Therefore, Mr. So-and-so learned consent pressed for quashment of the criminal proceedings in GR case number so-and-so, considering that there is unlikely would of considering that the chances of conviction are bleak and remote, which would be a abusive process of law. Next para. MS L. Hage, learned additional PP, fairly submits that since the petitioners had settled the matter among themselves, between themselves, and the nature of the injury is simple in nature, he would not have any serious objection if this honorable court pass appropriate orders quashing the criminal proceedings, quashing the present criminal proceedings against the petitioner number 1 to 4.
No.
Mr. I've considered the submissions of learned counsel for the parties, and also there is the case trial court records, including the charge sheet. The trial court records, huh? Who is the complainant?
Yamarasna, my
Respondent number
5.
Five.
prisoner number 5.
5.
Records reveals that the petitioners number 1 to 4 on being interrogated have admitted and have accepted that on 13/10/2024 at around 21:30 hours to 2300 hours, they had an argument with the respondent petition number 5 at railways in the railway track near railway station Naharlagun, and ensued followed by scuffle, due to which resulted in causing resulted in which the petition number 2 number 5 has sustained minor injury. Mr. The petitioners number 124 have also assaulted one Sri Subhas Nidak, who has also sustained a simple injury. Mr. Considering, continue, above, it is seen that a prima facie case against the petitioners number 124 appears to be established so far as the investigation report is concerned. However, the parties, the petition, the complainant, public victim, and the accused persons have entered into a settlement on 20, what is that?
30,
30
yes, 30 August.
08/20/25. And having considered that the incident had arisen out of misunderstanding between the petition, the petitioner number 1 and petitioner number 5. All right. Thereby, please stop. The settlement has been entered into on the intervention of the family members and well-wishers. Please stop. The petitioners have agreed to maintain peace and harmony among themselves. Please stop. Next bill. Having considered that the parties have entered into a settlement to settle the misunderstanding between them and to maintain peace and harmony in future, and also considering that the scuffle ensued due to misunderstanding, and also coupled with the fact that the injury sustained was simple in nature. The proceedings criminal proceedings, the continuance of criminal proceedings, in my view, would be abusive process of law as the, and as, and in view as the parties have settled the matters and their the chances of conviction of the accused persons remains bleak. Then you just give that. In the case of so and so, having considered so and so, next para, of the considered view that this is the present case, one of the cases where the inherent power of this court is fit to be exercised accordingly so and so. The criminal proceedings in JR case number so and so under section so and so against the petition number 1 and 2, 1, 2 and 3, 1, 2, 3 and 4 pending before this so and so is hereby passed. Criminal petition instance disposed of.
All right.
I live more.
Item number 18.
Finisher of before 12.
Your Lordship,
1.
I have taken step on 16 May 2025.
Heard
Correct.
Mr. So and so and Mr. So and so. Service reports, ever service reports, list after 4 weeks.
Your Lordship, interim is there, that may.
Interim order pass earlier shall continue. Yes,
Obliged.
pass.
Item number 19.
My Lord, today I am entering appearance for respondent number 2, Your Lordship.
Heard Mr. L. Permelan, counsel for the appellant, and also
for-
heard Mr. El Perme, appellant.
My-
No,
Yeah, I am correct.
and Mr. Soms, T. additional PP for the state. You are appearing for
Respondent number 2.
Mr. So and so
Big.
enters appearance on behalf of respondent number 2.
Yes, sir.
Then what is to be done?
Paper not yet received. Your Lord.
Huh?
Paper.
The registry to furnish copy of the paper book. Registry to furnish paper book. Copy of the paper book to the learned counsel, Mr. So and so. For respondent number 2. Yes, next.
I, my Lord, yes, interim order, that may be kindly continue.
IA
I, my Lord,
is a
interim order, my Lord, that may be kindly continue.
interim order of what?
Interim order, my Lord,
You have been released on bail.
my Lord.
The interim order in. Then in that case, IA is not disposed.
Not disposed of. Can be disposed of otherwise, Your Lord.
Yes,
Yes, I have no objection. In
it's an interim order. It has not been considered fully.
No.
It was not disposed of, it was considered, and the earlier bail which has been granted before the trial court, that was continued. But the IA was not disposed of by this court.
No,
Was
is there any reason? Reason to,
No, my lord. Reason is, my lord, since the victim has not appeared.
only for appearance of victim, my Lord, that was the offense, my Lord, wherein I have to convicted, this is bailable offense, my Lord. Accordingly, landed trial court, my Lord, grant me 45 days, my Lord, to file appeal, my Lord.
no, there's no reason order. So we'll consider.
Okay.
Interim order passed in IA so and shall remain, shall continue.
High level.
We'll have to disposal, you have to consider on
Yes, yes,
of the application.
okay.
All right.
Obliged.
Yes.
Item number 20.
4 weeks. Yes.
May Lordship, we have already received the paper copy, Lordship. The
Ah.
matter can be fixed after 2 weeks.
So it's for hearing then in that case. We'll fix for hearing.
Yes, yes.
Heard Mr. So and so, learned counsel for the petition. And Mr. T at the learned initial PP and Mr. D Laji learned legal aid counsel.
So the amicus, not on
Amicus Curiae, huh? Parties have been punished with the paper books, huh?
Yeah.
List of. What is listed for orders today? In that case, we'll list for hearing in the usual course.
Yes.
And it is admitted already. It has been admitted already. Oh. So. Doesn't make a difference.
Not list. Legal aid.
Not necessary. We can appoint you.
Distinction regarding legal aid and humanitarian.
Ah.
That's different before.
Legal aid, you will be, the fees will be paid by the legal service authority. We'll make it legal aid, doesn't make a difference. Amicus is sounds, I mean, better.
Our High Court has prepared list of amicus and
Doesn't matter.
legal aid.
It's okay, since you have been appointed. Okay. Any difficulty? No?
No.
Yes, next.
Item number 21.
Limited time and others. What is this? That matter?
Lordship, on, yes,
Yes.
Your Lordship.
Yes.
There were two issues that were raised.
Limitation Act, Application of Limitation Act on 482 or 528 of the BNSS.
Hmm.
And if it is dismissed on default, the power of exercising to restore the same, my lord, recall the same.
Hmm.
So, my
Your
lord,
Lordship, with regard to the same, I have a case law of the Honorable Himachal Pradesh High Court, wherein one of the
We'll consider after, we'll take it after some time. Yet to, we'll finish the
ma'am.
other cases. 22. For a time being, maybe after the break.
Yes,
after the
ma'am.
lunch break.
Yes.
Item number 22.
Yes,
In this case, I have filed my additional affidavit. This matter may put up for admission hearings.
is there
Break that-
respondent, parties are really represent. No
But it
private.
is settlement, my lord, we have raised an objection since there is a
Okay.
piecemeal settlement. So,
Heard Mr. So-and-so learned counsel for the petitioner who submits that he has filed an additional affidavit. You have received,
yes, my lord.
Mr. T at the learned additional, the PP is first arrest for the state, huh? List after 3 weeks
3 weeks.
for admission.
Obliged, your lordship.
Obliged.
Item number 23.
Service report in respect of private respondent number 1 to 3 are still awaited.
Heard Mr. K. Lolan, learned
Lordship,
counsel for the petitioner. Award service report, list after,
Lordship may be allowed to take fresh steps
okay,
by register first as well as justice service.
okay. Then in that case, that will say. Mr. K. Lolan, learned, only prayer, Mr. K. Lolan, learned counsel for the petitioner. Further, a week's time is granted to take fresh steps by registered post as well as dusty mode.
Yes,
Ah.
Lordship,
List the matter after 3 weeks.
3 weeks.
Hmm.
And Lordship, there is an interim order that may be
Interim order passed, earlier shall continue. Yes.
deeply obliged.
Item number 24 and 25.
May I please?
Hmm.
My lord, I have filed IA praying for withdrawal of the AB number 160 of 25,
160,
2 of 2025, AB number.
why?
Your Honor, in this case, Your Honor, on dated 28/10, this honorable court has granted interim bail
Ah.
to the applicant. On the same day, another application was filed before the district and session judge Zero.
Zero also granted bail.
Yes, absolute granted the bail.
Anyway, the Mr. So-and-so learned counsel for the petitioner submits that he may be allowed to withdraw his bail application, huh? Mr. T at the learned additional PP is present, accordingly, bail application stands disposed of on withdrawal, huh? In view of the orders, so-and-so passed in IS so-and-so disposed of, huh?
Obliged.
Both disposed of, huh?
Matter number 26.
Yes, first. Yes, what is this?
Yes, my lord, it's a criminal petition wherein your lordship, the proceeding, the order was stayed, impugned order was stayed, wherein the direction for re-examination.
Mr. T at learned additional PP. Office note indicates that 29/10/20, dated 29/10/2025. Office note dated 29/10/2025 reflects that trial court request is yet to be received. And the service report in respect of sole respondent is awaited.
Yes,
List in view of list after 2 weeks, 3 weeks.
3 weeks, man.
Ah.
Obliged.
Matter number 27.
My Lordship, I beg to mention this item. So, I on behalf of Tito Po, is out of station due to health issues. And we have taken consent from the other party also.
Yes.
Therefore, Lordship, this matter may be adjourned for, and this matter.
Not
picks up
Mr.
at
So-and-so learned
3
counsel
weeks.
for the petitioner and Mr. T at the learned assembly. The on 7th,
Obliged.
list on 7, huh? As agreed to by parties. Learned counsel for list on 7.
My lord, let it be on, my lord, I'm sorry, my lord, let it be on 11th, my lord.
11, huh?
Yes, man. Obliged, your lord.
Item number
Obliged.
30.
Yes. Why hearing? Urgency is there.
Not exactly. In fact, now, my learned friend can maybe help me.
Huh?
I have no instructions from the petitioner. It's been 7 years now.
Cannot be ruled.
I'm given to understand that the respondent has remarried now, whether she's interested in this or not. Whether I'm paying the money of the debt also, I am not aware. I am told that the complainant has now remarried.
The fact that the respondent number was already married and had
Yeah,
husband appointed.
she took me into marrying her actually. I was told yesterday that the complainant is now married to the lawyer who represented her in Allahabad.
And then matter ends there.
No, but
Or
there's a
even if,
direction,
even
but
if it's,
now I don't know if I'm making a categorical statement.
Hmm.
If the child is mine, I will pay for his, I will have to do that. Now, she's always in under such circumstances, marriage was done, she was already married. I'm not sure if it is my son. I
so
want-
you obtain instruction,
Yes.
find out what is the exact status. Of course, 2018 matter.
Yes.
Find out.
No contact, the all number is not working.
My lord, I will make an attempt. I have talked to the council who has engaged me. I have asked them.
Yes, yes. They heard Mr. Deepang learned counsel for the petitioner and Mr. Yu Bori learned counsel for respondent. Respondents, right?
Yes.
Considering the matter, they having considered the matter and as spread for by, as submitted by Mr. Deepang, as submitted by the parties, huh? Come on, let this matter be listed. After 3 weeks,
Yes, but
3 weeks. So as to enable the parties to obtain instruction with regard to the status of the respondent number 1.
yes.
I think 1 and 2.
One is- yes,
Respondent number 1 and 2. He's a child. Already you are having a child. She was having a child.
No, my lord. This respondent number 2 was born when we were married. But
Okay.
the problem is that she was already married.
Before,
Yes.
While she was married,
after your
it
marriage,
led me into marrying her. On that ground, we have been.
then out of that, this.
I don't know. That is why. Why I wanted.
But
to
then
hear
it
that-
was, he was born.
Yes, yes.
He was born
After.
during the subsistence of your marriage only. You find out.
Yes.
It's very difficult.
Of course.
I mean, in the process, the child will unnecessarily suffer.
Yes, yes.
Lordship, item number 21
We'll
is there.
continue.
Two, Lordship.
Lordship, the
Item number 21.
PP is on his way.
Mhm.
Lordship,
Yes.
The last occasion, the two issues that were raised
Hmm.
is one, whether this honorable court will be barred to dismiss a criminal case
Hmm.
registered under section 482 CRPC.
Hmm.
And to that effect, your lordship was right in saying that only appeals and revisions are barred. However, under section 482, since it is the inherent powers of this honorable court, and the powers are quite wide and they are discretionary powers, so we cannot say that it was barred. However, there are, in such cases when the matters are dismissed, there is a provision for restoration under section 482 CRPC. If your lordship will look at the judgment that I have provided, which is Geeta Kumari and Ananda versus State of Himachal Pradesh. At para 10, your lordship.
Yes.
At para 10, your lordship will see that in KD Kerala Kumaran Nair versus State of Kerala and another, after examining various cases on the subject, the Kerala High Court held that an order dismissing an appeal for default does not amount to judgment or final order within the scope of section 362 of the code, and further held as under. That first is that a criminal appeal shall be disposed of only after perusing the record and hearing the appellant or his pleader if he appears and the public prosecutor if he appears. Second is that a criminal appeal can be decided on merits only after hearing the appellant or his counsel. Lordship may come to the third point. at page 4. The High Court has powers under section 482 of the Code of Criminal Procedure to dismiss any appeal or revision or any other criminal proceeding for default or non-prosecution. Lordship, I believe this point covers that question whether the dismissal order
yes.
can be passed or not.
Then limitation.
For limitation,
Yes, my lord, so far as limitation is concerned, my lord, the Limitation Act will not apply while invoking 482. However, your lordship, the delay and losses in preferring the 482 application, that has to be reasonably explained and sufficient cause has to be shown. Otherwise,
No,
your lordship,
it's not a question of delay. It's not only question of delay in filing the 482,
yes, my lord.
delay in filing the restoration petition.
Yes, my lord. The restoration petition will be under 482 application, my lord, because when there is no any provision in the code to deal with a matter, in such case, my lord, the court has to invoke its inherent power. That is,
No, that's why. I mean, what if Limitation Act it doesn't apply
yes, my lord. It's
for
not applied.
restoration?
Yes, my lord. The judgment is here, my lord. So far as this limitation is concerned, my lord. In
For restoration application.
yes, my lord. Because the restoration, there is no any provision for restoration under BNSS, my lord, in criminal procedure code as well as criminal procedure code. It is restored basically.
Then let us see the Limitation Act.
Yes, my lord.
What the article you are?
Article 114.
120.
122.
122, under 122.
To restore a suit or appeal or application for review or revision, dismissed for default of appearance or for want of prosecution for failure to pay cost of the
That is only with regard to civil disputes, your lordship.
application in
decision.
specific for leave to appear and no instance.
This is not apply for criminal case, my lord.
So what is to be done?
My lord, the one judgment that was rendered by the Jammu and Kashmir High Court, your lordship, many judgments has been reiterated, which has been dealt by the various High Court, my lord, on limitation. My lord, from para 7 onward, my lord.
No, relevant. You just tell us which is the most relevant.
My lord, here, so in some of the High Courts, it says, while you're drawing your lordship analogy between criminal revision power for revision and 482, it was held that although Limitation Act is not governed, however, your lordship, the 90 days will apply. It was just your lordship, the observation given by the Delhi High Court. But it says, my lord, if there is a delay, clearly says in all these observation, my lord, the Limitation Act will not apply. Why I am saying so, my lord? Because your lordship, the court, while dismissing the application on dismiss for non-prosecution, that order itself is passed in exercise of inherent power. So that order was passed. Since there is no any provision for, my lord, the dismiss for non-prosecution in BNSS as well as in the earlier code CRPC, my lord. The order is passed under the provision of 528 itself, my lord. So now for restoring the same, if, my lord, if the order is passed by considering the merit of the case, then, my lord, the power to review is not there. 362, it is barred by 362. But the several judgment, my lord, is there, which says, my lord, if it is not dismissed or disposed upon merit, then for ends of securing ends of justice, the court can invoke its inherent power and restore the, your lordship, dismissal order.
So no limitation will apply.
Yes, my lord. My lord, kindly.
Then you dismiss case, you withdraw, you file a restoration plea. This is for dismiss case
For
is for
restoration.
this is not for delay, condonation of delay.
No, your lordship, it was for restoration of the criminal petition.
Okay, then we'll restore it.
Yes.
Yes,
This
my
is
lord.
not divorce. Hard miss MS so and so. This is for restoration only.
Restoration only, your lordship.
Why then we have gone into this limitation?
Because I had mentioned in the petition that there is a delay of 40 days since the passing of the order. So the learned PP was stating that I have not filed a separate IA for condoning the delay. That was
A reasonable explanation has to begin. Although Limitation Act is not applied, but your lordship, the reasonable explanation has to be.
That applies to there is a case by this court only in writ petition review.
Yes, my lord.
review, for filing review
Yes, my lord.
in the writ petition. There was a
My-
debate also.
Here also, my lord, in criminal case, my lord, review is not permissible. There is a specific bar under 362.
Yes, that is there.
But if it
In
is not
criminal
disposed
case,
for-
review is not permissible.
Yes.
Heard MS so and so learned counsel for the petitioner and Mr. T at the learned additional PP for the state. This is an application praying for restoration of criminal petition number 72 of 2025, which has been dismissed. But it is. What the order of dismissal?
Page 14, page 13 and 14.
Has been dismissed
For non-prosecution.
for non-prosecution. For restoration of so and so, which has been dismissed by an order dated 13/08/2024 for non-prosecution. Please stop. What is your ground? The petitioner has, petitioners have filed. Petitioners, right?
Petitioners.
Petitioners have filed a criminal petition, which has been registered. Above the criminal petition, being criminal petition number 72 of 2025. That is the next para. Seeking quashment of FIR in Niti Bihar PS case number 15 of 2021 under section 324, 448, 341, 34 IPC 1860. And the consequential criminal proceeding pending before the Chief Judicial Magistrate UPA on the basis of the settlement between the petitioners, right?
Petitioners.
When the matter was listed on
7/8/2020. 7/8/2025. 7th August 2025.
There is what?
That was the first appearance that was missed. 7/8/2025, we could not appear, Your Lordship.
Then
Thereafter, on 13/8/2025, the matter was fixed. That date,
listed
so we could not appear.
on 07/08/2025 and 13/08/2025. The learned counsel for the petitioner has failed to appear. List of considering that this court, having considered that on 2 consecutive dates the learned counsel for the petitioner remains unrepresented, the criminal petition was dismissed for non-prosecution. For the reason that the petitioner appears to be no longer interested to pursue the matter. Please stop. Where you have stated your ground?
At page 4, Your Lordship, on para 2.
It is the submission of learned counsel for the petitioner that when the matter was listed on 07/08/2025 and 13/08/2025 at this admission stage for admission hearing. Unfortunately, the counsel representing the petitioners could not appear. Please stop. Please stop. It is the contention of learned counsel for the petitioners that she was and for adjournment of the case. Mr. However, the junior associates could not appear on the two dates, as a result of which the petitioner, as a result of which the criminal petition has been dismissed for non-prosecution. Mr. Mr. She submits that due to fault of the counsel, the petitioner would suffer if the criminal petition is not restored. List of. You have no objection?
No objection, madam.
Hmm.
For end of justice.
Mr. T. Learned additional public prosecutor fairly submits that since the petition, criminal petition has been dismissed for non-prosecution due to absence of the non-appearance of the learned counsel for the petitioners come up, you would not have any objection for the ends of justice, huh?
Yes, ma'am.
List of consider have been considered. That no. It is true that an appeal or revision cannot be dismissed for what default non-prosecution on merits. However, in the application under section 482 may be dismissed for non-prosecution or default. What is it? Not however, it is true. Not however, it is true that, no appeal or revision on merits, on merits. The petition application under section 482 may be dismissed for non-prosecution or default, and there would not be any bar to restore the petition if sufficient cause is shown for its restoration.
Yes, my
List of having considered above. And on consideration of the grounds for non-appearance and for restoration, this court is satisfied that a sufficient reason and cause is shown by the petitioners for non-appearance and the consequential non-appearance on the dates when the matter was listed and and in the consequential dismissal of the criminal petition for non-prosecution. Because I am of the considered view that the criminal petition can be restored to restored list of according the criminal petition 72, number 72 of 2025.
72 of the, no, you're
Huh?
not 2025. 2025.
25.
25.
25. Be restored to file, huh?
GPF.
The miscellaneous application instance allowed in disposal.
Direction to list the matter accordingly, the main case,
The
after a week.
criminal petition in view of and to be listed.
That may be
Do we need
reflected
to
in,
pass the order.
since it's a restore, my lord, the main, in this case, my lord, there is the direction may be given to list after 1 week or maybe after 2 weeks, the main.
2 weeks.
The criminal petition be listed after 2 weeks.
Yes, madam. Deeply obliged.